The Ohio eviction notice. What is an eviction notice? Eviction notice, or notice to quit, is a letter sent by the landlord to the tenant notifying them that they should either take or stop a certain action or vacate the rented premises. Eviction notice can be of two types. Conditional, when a tenant is given time to remedy the breach of the lease, or unconditional, when a landlord terminates the lease without any alternative options for a tenant. What should an eviction notice include? Information about the tenant and the landlord. The reason for sending the notice. The date by which the tenant should take or stop a certain action. The consequences of non-compliance. The date and way of notice delivery, and the landlord's signature in the form of certificate of service attached to the notice. How to evict a tenant in Ohio. Non-payment notice. According to the Ohio legislature, rent is considered late after the next day it is due. If the tenant fails to pay rent when it is due, the landlord should send them a 3-day notice to pay or quit before evicting them. Non-compliance notice. When it comes to other violations of the lease, the state laws require the landlord to send a written notice to the tenant, giving them 3 days to quit the premises. They are not obliged to give the tenant the time to correct the issue. In case the tenant's violation materially affects health and safety, the landlord should provide the tenant with a 30-day notice with the intent to terminate the terms of the lease if they don't remedy the violation within the given time period. However, when the tenant is involved in sex offenders or illegal drug activity, they should be given a 3-day notice to quit before the contract is terminated. What if the tenant fails to comply? If the tenant fails to comply with the rules of the lease, the landlord can file a complaint with the county or municipal Ohio court. The filing fee will depend on the county. For example, in Franklin County, the fee is $123. Then, the tenant should get the complaint and summons within 3 business days of the date when the complaint was filed with the court if the eviction case is based on illegal drug activity, or within 7 days for all other eviction cases. It should be done by the clerk of the court. The tenant can write a formal answer, but it is not the state's requirement. The tenant's failure to appear for the court hearing might result in a judgment in favor of the landlord by default. If the landlord wins the case, a writ of execution will be issued. Then, tenants will usually have no more than 10 days to move out after an authorized person receives the writ of execution.